the EU Maritime Security Strategy and Climate Change, the case of maritime transportation and new challenges ahead. Climate change has become one of the most critical concerns for mankind and urgent action is needed. The European Union or EU Global Strategy of 2016 also considers climate change as a severe factor that may disrupt economic growth and endanger both citizen and territory. The International Maritime Organization or IMO sought but failed to reach a binding international instrument to regulate shipping pollution. Consequently, the EU decided to act approving Regulation 2015 per 757 on the monitoring, reporting and verification or MRV of carbon dioxide emission from maritime transport. This article analyzes the different kinds of jurisdiction foreseen in the United Nations Convention on the Law of the Sea or UNCLOS, the role of current actors and the latest step taken by the IMO. The common concern of climate change and the role of the IMO. Carbon dioxide emission from ship pollution constitute one of the most important concerns for states and supranational institutions. From 1990 to 2008, emission from EU-related shipping increased by more than 48%. Worldwide, total ship pollution amounts to more than a billion of carbon dioxide tons per year and is set to increase from 50% to 250% in 2050. Hence, at the global level, this emission represents 3% of total emission and may reach 5% by 2050. Climate-based risks and threats are already evident, even if some actors continue to harbor doubts. In light of this, several governments securitize the environment. A key focal point is how pollution has increased the vulnerability of the high seas. The high seas are key for maritime transportation and trade and are part of the global commons, a common concern of mankind. This paper analyzes EU Regulation 757 per 2015, which adopts a system of monitoring and verification to control carbon dioxide emission from shipping pollution. Climate change has become a real threat requiring urgent action by regional actors such as the EU. Global actors encounter many obstacles in the quest to adopt a binding norm. Discussion to build consensus and develop solutions are critical, but also time sensitive. This paper will analyze the scope of application of the norm, taking into account the existing norm in force and other international law sources. The paper will also take into account the different actors concerned in order to understand the scope of obligation of each of them. Climate change has been considered a problem of common concern as it can alter the physical, chemical, and biological characteristics of the ocean. Consequently, its effect can jeopardize the lives of human beings, causing social and economic impact and even violating fundamental rights. At the international level, Articles 192, 194, and 204 UNCLOS already acknowledge the problem of maritime pollution. However, in 1982, the perceived problem and role of climate change was such that it had yet to be included on the international agenda of government and supranational institutions. In 1992, the United Nations Framework Convention on Climate Change, or UNFCCC, was signed and called for the widest possible cooperation from state and different actors to tackle climate change. Further effort led to the adoption of the Protocol of Kyoto 1997. Article 4.5 of the protocol establishes the sharing of burden in connection with climate change commitments. Moreover, in connection with the specific problem of maritime transportation, in relation to the limitation or reduction of emission of greenhouse gases, Article 2.2 specified that the IMO should pursue this. The organization's scope of function is set out in Article 210 of the 1948 IMO Convention, which is considered to constitute a very broad marine pollution remit. As for the internal structure of the organization, Article 38 of the Convention established the Marine Environment Protection Committee, or MEPC, as the organ in charge of considering any matter in relation to the prevention and control of marine pollution from ships. Under the IMO's framework, several legal instruments related to technical requirements for maritime safety and pollution prevention have been adopted, such as the International Convention for the Prevention of Pollution from Ships, or MARPOL, International Convention for the Safety of Life at Sea, or SOLAS, and International Convention on Standards of Training, Certification, and Watchkeeping for Seafarers, or STCW. In addition, since 1997, several discussions on climate change and the emission from shipping have taken place, and the IMO has provided periodical reports detailing the organization progress on this issue. In 2011, the IMO passed binding measures to reduce emissions from international shipping and added a Chapter 4 to Annex 6 of the MARPOL Convention. The measures entered into force in January 2013 and introduced a mandatory Energy Efficiency Design Index, or EEDI, for new ships. All ships were also required to have a Ship Energy Efficiency Management Plan, or SEEMP. In 2013, the IMO also discussed the use of mechanisms such as the Emission Trade Scheme, or ETS regime, and in 2016, at the celebration of the 70th anniversary of the MEPC, a roadmap was agreed in relation to the global compilation of maritime emissions. The 71st Intersession Meeting, July 2017, and the second meeting of the working group agreed on an initial strategy regarding reduction of maritime emission. On 13 April 2018, Resolution MPEC 304.72 was adopted with the aim of establishing an initial strategy regarding greenhouse gas (GHG) emission from ships. Despite no binding instrument yet having been adopted, it seems that the IMO has taken a relevant step to solve this problem. Nevertheless, certain scholars have criticized the pace of development of IMO treaties. It may take longer than expected to adopt a binding norm or agreement. However, it may be too late to address the emerging and critical concern that is climate change. Interrelation between EU maritime security strategy and climate change action. On the basis of Article 21.1 and 2 of the Treaty of the European Union, or TEU, the EU has taken the lead as a global actor promoting action against climate change and, since 2007, in enhancing maritime security. The EU has sought unilateral action to end solution for maritime transportation and climate change by filling the normative gaps that were not addressed directly by the IMO. In October 2007, The EU Commission passed the Maritime Security Strategy with the aim of horizontally integrating sector-based maritime policies and action and enhancing Europe's capacity to face challenges of globalization and competitiveness, climate change, degradation of maritime environment, marine safety and security, and energy security and sustainability. Thank you.